This is Michael Popok, Legal AF. It's time to talk about Donald Trump's appeal chances. Is he going to take an appeal? What's it going to be an appeal on? Is it going to be reversed, his conviction, by the appellate court? Which appellate court? Are we talking about the state appellate court or the federal appellate court? And when can he appeal? And what happens to his sentencing as a result? I'm going to break it all down for you right here on this particular hot take. Special shout out to Stavis. He did a very nice job as also a practicing lawyer in New York in the New York Times op-ed piece about the appellate procedure in New York. I'm going to break it all down for you here. First, Donald Trump has a conviction obsession. He can't stop talking about the conviction on the campaign trail. Just to switch over to politics as part of law and politics here on our Legal AF hot take. And so that obsession, he talks about it constantly, the lawless conviction, the witch hunt, the kangaroo court, disparaging and undermining the validity of 12 jurors in New York that took time out of their busy lives to serve their civic duty and listen to the evidence and convict him. And that obsession, of course, while it may work to foment and whip up his red meat base, it doesn't do well with the swing voters. And that's what a lot of Republican operatives are worried about. In other words, keep talking about your conviction, Donald, because all you're doing for making sure that you're going to get the votes you are already going to get, you're losing votes that you need in order to win the election. Good on him. Let's switch places now, and talk about the appeal. Donald Trump and his proxies, Stephen Chung, his spokesperson, Alina Habba, even Todd Blanche, when he gets the opportunity as his lawyer, talks about his great likelihood of success on appeal. Let me shoot that down right now. The chances of Donald Trump reversing his conviction are slim to none. Just to give you a statistical backdrop, only 5% or so of New York convictions are reversed on appeal. It's not impossible. There are certainly convictions that are reversed on appeal, but 95% of convictions are either not appealed or they're affirmed on appeal. So that's the steep mountain that Donald Trump has to climb, 5% chance. And then you have to have reversible error in the record that led, as the appellate court determines, directly to the conviction. Reversible error, not harmless error in contrast. Reversible error means the person would not have been convicted but for this error that happened during the trial. Something about the indictment, something about the crimes that have been charged, something about evidence that was let in or shouldn't have been let in, something about a certain type of testimony, something about a decision by the trial judge in exercising his discretion to dismiss certain counts or not dismiss certain counts, allow certain witnesses or not allow certain witnesses, make decisions about if Donald Trump testified, what he could testify to, those types of decisions. Now, the Sixth Amendment of our U.S. Constitution does not guarantee a perfect trial. There's no such thing as a perfect trial. I should know. I've put on 35 of them in my career. It's not a perfect trial that you're guaranteed. It is a fair and impartial trial. Those two things are different. Error happens every moment, every day, in every trial. If it's harmless error, meaning it did not lead to the conviction, it's just part of the you don't get a perfect trial, you get a fair trial, mix. What's an example of a harmless error? During the, and this was in Stavis's article or op-ed piece in the New York Times, and it's a good one. It's a good example. When Stormy Daniels took the stand and testified, a lot of sordid, gory details about the sex related to her and Donald Trump, and about her fear potentially that she wasn't able to leave and that she was being physically prevented from leaving the room, suggesting that this was not consensual sex. In other words, another sex crime by Donald Trump, having already been adjudged of a sex crime in a civil context in the E. Jean Carroll case for abusing her sexually. That was the problem. But that's another one of those examples of it's error for the judge to have allowed that or for that testimony to have been elicited. It is harmless error because it couldn't possibly be argued that it led to his conviction, Donald Trump's conviction. They didn't convict him because they didn't like that one comment that Stormy Daniels made about the nature of her sex with Donald Trump. That's harmless error, if it's error at all. Again, reversible error is the one that leads to the conviction. Should Michael Cohen have taken the stand? The answer to that is yes. Should a mistrial have been granted by the judge when he didn't grant it? Was his decision not to grant a mistrial Was that an error? If that is an error, that's reversible error. The judge making a decision to allow the indictment to go forward with the two crimes joined together in order to make this into a felony. Business record fraud in New York, as everyone now knows or should know, is a misdemeanor in New York. However, if it is attached to a second crime, if there is an intent in making the business record fraud, if there is an intent to commit another crime or conceal the commission of another crime by unlawful means, then you have a felony. So that is where Donald Trump will likely try to argue for reversible error, that the judge allowed the second crime and he charged the jury on the second crime, which is New York election interference, meaning that Donald Trump tried to bury the Stormy Daniels affair by a payoff, which was an illegal campaign contribution, improperly and never reported under the Federal Election Commission Act, the federal crime, federal election crime, or it was a tax issue because it was listed improperly on the books and records of the Trump organization. Thumbs up on that as a legal expense to Michael Cohen. That is where they're going to try to pick at the thread and unravel this prosecution and argue it was reversible error to allow the judge, for the judge to allow this case to go forward with that as the second predicate act. Now let's unpack that for a minute. First of all, any argument that Donald Trump wasn't aware of the criminal charges against him and therefore couldn't mount a proper defense, that was sort of taken away by Judge Merchan, who in the middle of February, in a 20 or 30-page decision, laid out exactly what the indictment's charges were against Donald Trump and what he had to defend against. So that takes away any argument that, well, we couldn't figure it out from the indictment. We didn't know. And then it seemed to be a little bit wishy-washy during the presentation of the evidence. We didn't know exactly what the crimes we were being charged with. That was sort of taken away. The knees were cut out from under that argument in mid-February by Judge Merchan in issuing this very substantial substantive ruling about the nature of the crimes. So the only issue is going to be whether and there's two stops on the appellate train in New York. The first stop is the appellate department the appellate division first division. Let me try it again because I'm a member of it. I should get it right. The appellate division first department. The appellate division is the intermediary appellate court in New York. And then the state is divided into regions or in divisions. And the first division, first department, if you will, for New York covers Manhattan. Have you heard that the flavored air category is quickly becoming the leading alternative to vaping and smoking? It's a whole new movement towards better habits, led by the sponsor of today's video, Fume. Fume is an award-winning flavored air device, and flavored air isn't like vaping. If vapor was compared to sticky soda, Fume cores are closer to herbal teas. Fume has lots of delicious flavors to choose from, like crisp mint and orange vanilla. With flavored air, you can satisfy your oral fixation through a passive diffusion system that utilizes no electronics, vapor, or combustion. Instead, Fume draws flavor to your mouth. Fume fills the void ditching a bad habit can leave. There's no vapor, and you can use it anywhere. There's no nicotine, and it's not addictive. The non-toxic flavors are a guilt-free alternative. Fume doesn't use any batteries, so you'll never need to charge it. The design is super sleek, it looks awesome, and you can truly feel the weighted, high-quality design. I mean, one of the fun things about Fume is that it's made to fidget with and calms anxiety with magnets, snaps, and clicks. Fume continuously invests in third-party studies to ensure the safety of their products. My favorite Fume flavor is the orange vanilla. It's just as delicious as it sounds. And look, if you're trying to kick your bad habit, I couldn't recommend Fume enough. Fume has served over 300,000 customers, and you can be the next success story. For a limited time, use my code LEGALAF to get a free gift with your Journey Pack. Head to tryfume.com. That's TRYFUM.com and use code LEGALAF or scan the QR code on the screen to get a free gift with your order today. You have, as a criminal defendant who's lost, you have an automatic right, mandatory right to appeal to the first level court. right? The appellate department, the appellate division, first department, right? That's going to be where he's going as a matter of right. And they're going to have to look at these issues. Now, we know Donald Trump's going to throw everything at the wall and see if anything sticks. He's going to raise all the errors that he says the Judge Merchan made. But the focus here, the only one that really will probably, that the court will find interesting, the appellate court will find interesting, is about the second crime issue and whether it was properly charged, if it was properly proven. Of course, you always have the fact that 12 jurors did unanimously find against 34 counts against Donald Trump. So that's going to be the laser focus. Now, if they decide, which I believe they will, that the second predicate act of this particular crime, an intent to commit another crime or conceal the commission of a crime, and then having that knit in with the federal election crime or the tax fraud crime, that's going to be proper. Then if they decide that, really the appellate opportunities for Donald Trump have just narrowed considerably, because the chances of getting that second appeal to the Court of Appeals is even narrower. That is not mandatory. The intermediary appellate court is going to have to decide that they need guidance from the Court of Appeals. It's not an automatic right to get an appeal to the highest level court in New York, the Court of Appeals. You have to get permission from the intermediary appellate court, and that's probably unlikely. Only if it's something that they think there needs to be clarification about this particular body of law and the use of this body of law by future prosecutors and that type of thing. But short of that, they don't even take the case at the appellate, at the highest level of New York. It kind of dies right there at the intermediary appellate court, where most appeals do die in New York. They get resolved at that first level intermediary appellate court, and they never get any higher. That's unlike other states where you have a right to go to the Supreme Court of that state, for instance, for other reasons. But New York, it's a much narrower path to appeal. And then you've got, I just want to address quickly this argument that keeps getting floated by Todd Blanche and other people around Donald Trump, usually ones who are not appellate lawyers, and which is that there's a chance for the United States Supreme Court to weigh in. First of all, they're not going to weigh in unless and until there's a decision by the highest court of that particular state. So if it never gets to the Court of Appeals in New York, the likelihood of it ever getting to the Supreme Court is almost zero. But let's say it did get to the Court of Appeals. Even then, there has to be a fundamental United States constitutional issue that that at least 4 of the judges originally see as being presented by the conviction of Donald Trump. This is not a case where there is executive privilege. This is not a case where he was even president during the time. This is not a case where there is immunity or supremacy clause issues. And those are the ways that the Supreme Court finds a way in as a hook into a case. So that while they can try some sort of writ of habeas corpus and jump over and have the United States Supreme Court take an appeal, that is even a narrower path. And the chances of that are well under 1%. It's infinitesimal. And so while they talk about it, because it gives them a lot of, they get a lot of mileage out of it, right? They block the sun with these arguments. In reality, they're not going to get a United States Supreme Court decision, or involvement, not even with this MAGA right-wing 6-3 United States Supreme Court. So it's going to likely die with a loss for Donald Trump at the intermediary appellate level of the First Department. Now, timing. Let me just end the hot take on timing. The Donald Trump can't take an appeal, emergency or otherwise, until the judgment of conviction is entered by Judge Merchan, which hasn't happened yet. There's been a verdict of conviction, but a judgment of conviction, when it makes him officially a convicted felon, is on July 11th at the same time of the sentencing. At the sentencing hearing, where Judge Merchan will mete out a sentence, right, that fits the crimes. And I've done other hot takes, and so have other contributors, about the range from probation, community service, all the way up to a top of 20 years and everything in between. That's all on July 11th. Then that whole set of decisions, the judgment of conviction, along with the sentencing, kind of come together in a package, and that can be appealed from by Donald Trump, as I said, as of right, mandatory appeal to the First Department. That takes a while. The sentence will likely be abated or stayed until the appeal happens. The appeal could take over a year or more. And I don't really see a purpose for him, especially if the sentence has been stayed, which the judge is likely to do, frankly. He's not going to remand him immediately, even if there's incarceration involved, given his first-time offender and not necessarily a violent criminal, although we all like him to go in. It's unlikely that's going to happen. So he'll stay out. There'll be a full appeal on briefing. It's probably not going to be until a late 2025 event when we get a final briefing and an opinion, a decision by that appellate division. And then he'll have to try for another appeal. We're talking about a 2026-ish final resolution of the conviction of Donald Trump and his sentencing. That's just the way it's going to be. And even if he ends up getting somehow restored to the presidency, he's then going to argue that he can't be bothered with any of these appellate issues while he's in office for something that happened before he was a president. And then the appellate courts are going to have to decide whether, and that could go to the United States Supreme Court, whether those proceedings can continue if the off chance that he somehow gets restored to the presidency. We'll follow it all, just like I did there on MeidasTouch YouTube channel and on Legal AF. And after hearing this description on this hot take, now you know why we called it 4 years ago, Legal AF. It's on Wednesdays and Saturdays at 8 p.m. Eastern time, right here on this YouTube channel. You knew that. You're already here. Stay here. Free subscribe. We're building this network with our bare hands. Help us get to 3 million free subscribers, and then join us Wednesdays, Saturdays, 8 p.m. Eastern time for YouTube version of the Legal AF podcast. We curate the top 5 stories, the intersection of law and politics. We bring it to you right here with lawyers who know what they're talking about. And then on audio podcast platforms of your choice. If you like what I'm doing here on these kind of hot takes, give me a thumbs up and leave a comment. It sends the message that you want to see more of it. It's not ego, it's algorithms. And then you can follow me on all things social media at MS Popok. And my entire body of work, if you can believe it, for hot takes, is over on YouTube, MeidasTouch. Look under playlist or contributors. You'll look for Michael Popok. You'll find, I think it's 1,200 hot takes at this point. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.